Protecting personal health information by understanding your obligations under HIPAA is a very big responsibility for you as a Multnomah County employee. Today, we will discuss and show you examples of how to protect this information by verifying the identity and authority of individuals that request Protected Health Information, or PHI. We will also discuss how to comply with HIPAA's minimum necessary standards.
How can I help you?
I'm calling to check the status of my case file.
When someone calls requesting PHI, HIPAA requires that you identify who is requesting PHI and whether that person has the authority to actually receive the information.
I can help you with that, but for verification purposes, could you please give me your first and last name as well as your date of birth?
Asking for personal identifiers that can be compared to information in the county system, like name and date of birth, allows you to verify someone. Social Security numbers should not be collected unless it is required or permitted by state or federal law. Plus, they aren't always a verifiable piece of information in our system.
My name is Lisa Smith. I was born December 31st, 1955.
Now that you've identified the person, you must determine their authority. Authority can be automatic, presumed, or demonstrated. In this case, the caller is requesting information on themselves, so they are automatically authorized to receive their own PHI.
Your case file is active.
However, in another example, the individual may not be the same person they are requesting information about. So start by collecting identifiers to find this individual's case file.
How can I help you?
I'm calling to check the status of my sister's case file.
What is your sister's first and last name as well as date of birth?
Her name's Becca Brown, January 1st, 1944.
Thank you. And what is your first and last name?
My name's John Brown.
Now, you can check the system to match Becca's information and see if John Brown is listed as an authorized representative.
I see there is authorization on file. How can we help you?
John Brown has what is called demonstrated authority. Demonstrated authority requires a person to prove they have authority to receive the information requested. This makes John a personal or authorized representative. If Becca were a minor child and John were her father, who has not lost his right to parent, he would not need to demonstrate his authority because he would have presumed authority. Presumed authority means that a person doesn't need to provide proof of authority due to the relationship status of the individual in question. However, there is no presumed authority for parents that have lost the right to parent, parents when their children are over 18, parents of children in situations when the child alone is enough to consent to treatment and actually consents to the treatment, or partners or spouses of adults. So, if someone does not have presumed authority, they'll need to demonstrate their authority through different kinds of documents. For example, a grandmother may be able to provide documentation, like a letter of guardianship, for you to disclose health information about her grandson. Or, a daughter may be able to provide documentation, like a letter of conservatorship, to receive financial information about her grandfather. In some instances, a friend could provide a power of attorney document to receive PHI. The POA must be medical related and not be limited to, say, a power of attorney to sell their friend's car. These documents must demonstrate their authority, as well as state the scope of powers listed. Any contingency listed must have occurred and not expired. For example, if the power of attorney has an effective period from January 30th, 2015 to March 1st, 2015, then you can only disclose information during that period of time. A neighbor might provide written authorization or release of information to receive insurance or medical-related information. This is a very limited form of authority. For example, you can tell the neighbor that their friend doesn't have any insurance, but the neighbor can't use their authority to then enroll the friend in Medicaid. An authorization requires specific elements to be valid, and many departments have their own forms that include those required elements. So, use those as your guide. What happens if someone can't prove their authority through any of the above documents or assumptions we've discussed? A sister calls asking questions about her brother's new diabetes medication. She has no POA, guardianship, authorization, or anything else demonstrating authority. You can ask,
How are you involved in your brother's care?
She explains that she's in the hospital with her brother, trying to help him get info about the medications he is on. Use your professional judgment. These types of disclosures are permitted, but never required. If her answer seems valid, make sure there are no restrictions on file for the disclosure, or situations where more stringent confidentiality rules apply, such as for substance abuse information. And only disclose the permitted information that is within the scope of her involvement. Again, use your judgment here. In some instances, disclosures are required or permitted by law. In these situations, ensure the person is from an agency that is authorized to receive information and only disclose what they are allowed to receive. If someone calls that cannot demonstrate authority to receive PHI of an individual, you must seek verbal permission from the individual or just tell the caller,
I am unable to disclose that information without authorization.
Refresh yourself on your department's policies and procedures in regards to all these topics and be sure to follow them. HIPAA's minimum necessary standard requires our workforce to only use and disclose the minimum necessary PHI when required for our jobs. For example, you are asked to run a report for all interactions involving client A. You don't need information on any other client, so only run a report for client A. When you travel between county buildings, securely take what you need from office to office. Only request information that you need to do your job. If you don't need a Social Security number, don't include it on your system's request. When posting to social media, refrain from discussing your clients in any way. Be sure to review County Administrative Procedure HIPAA 7 for more information. If a provider asks for a client's entire chart notes and case history, we may disclose the entire file so the provider can render proper treatment, unless an authorization is otherwise required. The minimum necessary standard states in Personnel Rule 3-35 that county systems are for business use only and never for personal curiosities. Also, be sure to store PHI in secure locations and not on computer desktops or any personal mobile devices. And if you change positions within the county, your access must change with you. Notify your supervisor or the IT help desk at extension 84357 if you discover that you have access to systems that you no longer need for your new job. Remember, Personnel Rule 3-10 requires employees to report known or suspected privacy incidents, breaches, and complaints of non-permitted uses and disclosures of PHI. Any employee can directly report violations to the Good Government Hotline via 888-289-6839. Lost or stolen mobile devices should be immediately reported to the IT Help Desk at extension 84357. Please, report what you know as soon as you know it. The county, in some cases, must notify individuals impacted and the U.S. Department of Health and Human Services. Time is of the essence. For more information, visit the HIPAA Privacy Commons page at commons.multco.us/HIPAA-privacy.